Hello, everyone, and thank you for the opportunity to speak in this conference. The presentation I would like to share with you today is titled Opening Up Possibilities for Sojus Asylum Seekers, Incredible Stories Between Judicial Biases and European Sexual Imaginaries. Just to give you some first triggers of what I would like to speak about today, um, if we look at a burgeoning literature that recently has been developing about asylum in Sojus cases, the issue of credibility is still one of the most pressing and seemingly unsolvable issues that we face. One of the questions that we compose ourselves in this sense could be then, will credibility ever be solved? Or is it a structural issue that we can really not avoid when we deal with refugee status determination in general and in such cases? And in this framework, what is the role of scholars vis-a-vis legal practitioners, judges, and institutions? What can be our contribution, our constructive vision of this issue? The kind of contribution I would like to propose today is not at all an overview of the state of the art of Saudi asylum determination or credibility assessment in Europe or at other territorial levels. I'm not either trying to give any determined solution to the problem of credibility. I would just like to raise some critical points that I deem fundamental if we want to face this issue more productively. Just an overview of the presentation I would like to give. I will start with some legal and methodological introduction about my research. I will bring some evidence from the fieldwork that I've done, and I will share the sort of taxonomy of biases that I've tried to recollect, starting from this evidence. I will try and develop two possible explanations for the findings that I have, and then I'll conclude with some possible paths forward in our research. Just a brief context information. My research is set in the Italian context. I cannot go through all of the asylum procedure that is in force in Italy at the moment, but I would just like to focus on two aspects. The first one is that the legal framework is changing a lot, not only with the new Pact on Asylum and Migration from the EU, but especially concerning national forms of protection. So the kind of statuses that are recognized in this sense change quite frequently and arguably depending on political developments. On the other hand, the Supreme Court case law, Corte di Cassazione in Italian, has evolved a lot in recent years regarding the issue of the assessment of credibility and the assessment of credibility in Sojus cases specifically. If we compare the cases that I've copied here on the slide, that are just distanced by a few years, the first one from 2007, the second 2010, and the last one from 2021, we can see how much the Supreme Court position changes and evolves in a more progressive and expanded understanding, informed understanding of the assessment of credibility in these cases. Concerning the fieldwork that I have conducted, it was based in Florence, which is a quite special case in the Italian context because it's quite frequently deemed as one of the most progressive, informed, positive examples of courts dealing with these issues. And more specifically, I have chose to deal with the so-called second instance procedure. So the first and only appeal asylum seekers can go through in Italy after the first rejection of the claim from the administrative authority dealing with their asylum request. That is called Commissione Territoriale. So the Court of Florence, the civil court, a specialized section of the court, deals with this first judicial review of the asylum request. In order to study this context, I conducted 18 semi-structured interviews and analyzed 47 case files. Of course, there are some limits concerning the sample of the cases. Most of them concern gay men from only 9 nationalities, and most of them turned out with successful outcomes after the judicial review in a specialized section of the Florence Court. I'm talking about biases and limits in the selection because there's no open or any at all, any database in Italy listing and organizing all the asylum requests according to various data, including, for example, the reason for the request. So the 47 cases I had access to were selected for me indirectly by the judges that I managed to interview. Of course, other limitations concern the fact that I only have one case study, and that I have decided not to engage with interviews with migrants, mainly for ethical reasons linked to my professionality and my training in this sense. Even though, again, the case study is a single one, I do think some of the findings and reflections that came out, that can be drawn from this study, can be somehow generalized or reflected in other contexts, especially, as I mentioned before, for the very special position and reputation of the Court of Florence in Italy. Starting from some evidence from the field work, which was again focusing on the process of credibility assessment in Soggia's cases, I do have to acknowledge that there are some positive notes linked to positive developments in recent years in the quality of the assessment of credibility in Soggia's cases. That is also reflected by the fact that, as I was mentioning before, most of the cases that reach the specialized session on the Court of Florence end up in an overturning of the negative administrative decisions coming from the Commissioni Territoriali, so the administrative authorities dealing with the first assessment of the request. Nonetheless, many issues emerged during the fieldwork regarding the credibility assessment, first of all, linked with respect to the object of this assessment. So if we look at what judges think the issue to be assessed is, many of them still try and confirm, find proofs of the authentic sexual orientation of the applicants, which is not, as we know from guidelines, UNHCR guidelines, first of all, as it's not the main issue to be assessed. And there's also quite confusion about what are the limits of questions that judges can pose. For example, some of them still decide to ask about sexual lives and sexual information, intimate information, which is in principle limited by the Court of Justice case ABC from some years ago, while others decide to focus on more emotional information regarding personal psychological journeys of self-discovery. Many stereotypes and or expectations linked to the applicant's testimonies and stories were also found during the fieldwork. They emerged from cases and interviews. I've just shared on the slide some of the questions that judges kind of pose or expectations that they have, again, concerning what applicants will tell about their experience linked to their Sojisk elements back in their countries of origin. Sometimes it has emerged, maybe even more worryingly, how some problematic results of the credibility assessment in the court came from simple ignorance regarding basic queer issues. I've just mentioned two cases here that I encountered, especially the first one concerned a young gay applicant from the Gambia that shared upon request of the judge that in his sexual preferences were both being a top and a bottom in the homosexual sexual act. And the judge, based on ignorance about the meaning of these words, interpreted this story and this information as meaning that the applicant was feeling and acting as both the woman and the man in the relationship, which brought to a negative assessment of the credibility of the applicant and thus a refusal of the request. Other cases, which are, I would say, equally worrying, concerned other issues such as the performance of sex work or the presence or absence of romantic relationships that both became factors upon which judges somehow took decisions once again. Out of this evidence, I've tried to collect to reorganize the evidence in some groups of biases that arguably can affect the judge's assessment of Sojist asylum seekers' credibility. The first cluster, I called it identitarian, and is really linked to the kind of expectations that judges have regarding the affectivity, sexuality, and psychological emotional awareness that applicants should display and share during their interviews. The second one is cultural and is really linked to the kind of information that judges have and their stereotypes regarding the influence of the culture and cultural background of applicants' countries of origin in their story in connection to their sexual orientation, gender identity, or other Sojist aspects. For example, the relationship to the family, to their faith and religious community, to their communities in general, or even the kind of understanding of temporalities or understanding of relationships to the state, which are arguably different from general understandings of these aspects in Europe. The third one is called performative and is really linked to the expectations that judges can have regarding the way the applicants perform their story. So not really the kind of information that they try to vehiculate, but really the performance, how they do it, how they tell it, what kind of emotional involvement they show, with what clarity and what terms they share it. Also, regarding the performance of one's identity, linking, to the kind of expectations that judges have regarding how would or should a gay guy or a lesbian woman or a trans woman look and act like. The last one is informative and is really linked to the information that is accessible to judges to find support in their decision making. And I'm really talking about queer knowledge, but also country of origin information that is arguably not only lacking, but also quite poor regarding queer topics. Trying to give some explanations to this state of things, I would like to propose two different sets of, again, explanations. The first one is a micro explanation focused on the very ground level of decision making in the court. We can find different elements in this explanation. The first one is judges' training, which, as it emerged from interviews with both judges and lawyers, it's increasing for sure, but it's still quite lagging, and it's not enough, especially regarding Sojist issues. And that can also explain how judges are often facing lack of terminology, concepts, and other basic knowledge or techniques for Sojist interview. The second factor is really the availability of resources, including time. So many judges shared how the huge backlog they have to deal with, the time they can dedicate to each interview. And while they try not to diminish the quality of the credibility assessment, for sure, also according to lawyers' opinions, this has an impact on the kind of attention and study that judges can dedicate to each single case. Lack of resources also concerns the absence of or non-regularity of presence of other kind of professional competencies in the court. And I'm referring to a varied array of competencies such as anthropologists, geographers, international relations experts, sociologists, and other kind of professionals. The third factor of a micro explanation will concern the fact that according to judges, according to the words during interviews, asylum law is a quite specific and peculiar field of law because it's really linked to emotionality and sometimes verges towards extra legal aspects of the assessment they're supposed to take. So not only judges spoke about the interdisciplinarity that is requested of them to really manage and take decisions on a case-by-case basis, but they also talked about extra legal aspects of this field of law that makes it somehow a hybrid field of law. And this, of course, compared and summed with the lack of resources of additional professional competencies, for sure has some consequences on the quality of the credibility assessment. If we turn to the macro explanation, as some scholars, I'm thinking of Calogero Giammetta, for example, or Francesco Romano Maturo, for example, have brought up, one could wonder if the rapid and quite recent opening up of international refugee law and refugee systems to the inclusion of SOGI's claims, coupled with an increasing closure reinforcement of borders and enforcement of violent border control measures, how do these two factors sit together? Can Sojes Asylum and the recent evolution of the inclusion of Sojes Asylum in the broader refugee system can also be read as a political move somehow? If we think about, especially I'm referring here to the Western context and Western border governance, if we think about the discursive normative power that asylum law has, in the sense that it really governs the exclusion of some subjects from the territory of states, using sometimes, again, discursive aspects of this field of law to justify also at a moral level the inclusion of few people while trying to cover up for the exclusion of the many, it would only be fair to ask and wonder whether Sojis Asylum has a role to play in this. The question in this sense would be, who really deserves to be included in the refugee system and why? If we have evolutions in the refugee system, why do these evolutions happen and why? What are the rationales behind it? I tried to give some answers and find some answers to this question, looking in the literature dealing with the concept of sexual democracies. I'm thinking about Fassin, for example, here, and homonationalism as a lens to read the relationship that the West establishes with third countries on fault lines that are drawn along discourses that deal with LGBT rights and queer topics. If we look at the case law of the European Court of Justice, the European Court of Human Rights, there's already literature. I'm thinking of Thomas Pickerbor, Francesco Romano Maturo, again, that trace how in the cases that these courts deal with, also including the cases of concerning Sojis asylum seekers, we can find homo-nationalist judicial traces in the kind of reasonings that the courts develop. If we take this into consideration, once again, it's only fair to wonder whether homo-nationalism has some role to play in how Sojis credibility assessment is somehow maneuvered, controlled, or to explain what are the underlying dynamics that somehow steer the evolution of the assessment of credibility in Sojis cases. In this sense, we can really take a new look upon the credibility assessment in these cases, seeing how Sojis asylum applicants are somehow caught up in a double bind that makes them both citizens of those homophobic countries that should be differentiated for the progressive homophile West, but at the same time also trophies of the West, in the sense that those few that can manage to get into our countries, while and when only when they are they manage to receive a successful outcome of the credibility assessment, only through, again, all those stereotypes that we mentioned before that are pretty linked to Western understandings of Sojist elements and LGBT identities, they really do become trophies of the West in the sense of perfect examples of the Western narrative or of individual liberation and empowerment also from the point of view of LGBT rights. Trying to go towards the conclusions, what can we say about the first question we started from? So is there a way out of credibility? If we look at our work, for example, of Jana Wessels on discretion reasoning or of Jenny Milbank on discretion and credibility, we could argue that credibility is just part and it's ingrained in the very system of asylum law, and it's part of the game of a continuous redefinition of the scope of protection that the system allows. in this sense, scholars should try and understand from the privileged point of view that they have out of the concrete legal practice, how to position themselves along the way of credibility. So not trying to find final definitive solutions to this issue, but tactical positionings in order to face this issue in the best way possible for asylum seekers. Of course, and once again, I would try to draw from from the evidence and information I gather from the field. Judges and lawyers themselves are already coming up with solutions, for example, regarding the training and presence of more staff in reception centers with more professional training, some strategies to support the disclosure of life trajectories of applicants in order to support the credibility assessment of their claims, but also, once again, the need for an increased interdisciplinary professional profiles to support judges in adjudication. But really, from a scholarly perspective, I would like to conclude with three brief points. The first one, if it is true that credibility is not really something we can detach from, that is just part of the refugee system, then we can frame our engagement in scholarly research as an endless research that should provide a continuous, scrupulous monitoring of the practices that are linked to credibility assessment in order to develop, again, a tactical strategic approach that can help people in this framing. The second one I would suggest should be also denormalization of the legal nature of asylum procedure. As we've seen from the hybrid nature declared by judges themselves about asylum law, we should not give for granted that determination of credibility and determination of refugee status is just per se a legal process. We can and should, in our research, imagine other ways, other fields, disciplines to look to in order to support this process and to free it from state power. The third one is sort of invitation, because as we've seen, the kind of normative interventions that appear during the refugee status determination process in SOGI's cases, if it is true that what I've tried to develop in the micro explanations that I try to propose is that, again, non-legal normative orders intervene in this process, and they are for sure politically driven. So we should always try to take a look at the broader picture of the refugee system and frame our research also in specific context, remembering of how much of politics stays and exists in the legal framework that we're dealing with. So this is all, and thank you very much for the attention and for this opportunity once again.